Thank you for joining Friedman Consulting today for a Friedman Consulting webinar. A couple of things you need to know about CLE credits. To obtain CLE credit for this seminar, you have to attend the entire seminar. It's 1 hour long. You also need to listen and watch for 2 codes. You'll hear 2 different codes. The first will be offered approximately 1/3 of the way into the seminar, and the second will be offered approximately 1/3 of the way or prior to the end of the seminar. And you need those codes, so be sure you write them down. Because at the very end of the seminar, you'll see that there's an attestation form with your written materials. You need to complete that form, and you'll see a space on that form for those 2 codes. Write the codes down and sign and submit the form within 1 week of completion of the seminar. If you have any questions, please feel free to send us an email. You'll find our contact information with the materials. Today's seminar is Buying or Selling a Law Firm, and it's my pleasure to teach it to you. My name is Jennifer Ellis. I'm Vice President of Friedman Consulting. Just so you know a little bit about me, became Vice President of Friedman Consulting in April of 2011. I left PBI to join Friedman, and I was with PBI from 1999 through 2011. The final position I held at PBI, a position I held for some time, was Associate Director of Media Technologies, where I was involved in a lot of the law practice management seminars as well as technology seminars that PBI offered. I graduated from Weiner University School of Law in Delaware in 1998. So that's enough about me. Let's talk about buying and selling a firm. Now, one thing you need to keep in mind when it comes to buying and selling a firm is that informed consent is a crucial part of this. And by informed consent, I mean the consent by a person to a proposed course of conduct after the lawyer has communicated adequate information and explained about the risks, material risks, and the right to avail themselves of alternatives. So in plain English, what does that mean? That means obviously clients are greatly impacted by the selling of a law firm, and those clients need to be told of what's going on and what their rights are. Now, there's a tension here throughout this process between when it's time to tell the client what's going on, when do you need to get the informed consent. And that's something I'm going to talk about because there's actually an ethics guidance opinion from the Pennsylvania Bar Association about that very issue, because you'll see that there's actually a conflict between when it is appropriate to tell the client. Do you tell the client when you're shopping the firm around, or do you tell the client when the sale has actually been made? And we'll get into that. Don't be afraid to ask for guidance. I mentioned the PBA already, and they have an ethics hotline. That number is 800-932-0311, extension 2214. Give a call over there if you're talking about selling a firm and you're not quite sure of all the ethics rules. There are a lot. I'm going to be going through a lot of them as I walk us through this process, and it can be very complicated. Don't be afraid to ask for help. You can also look on the PBA website where they have a database of ethics opinions. You do need to be a member of the PBA to access these opinions and to utilize the hotline. Just keep that in mind as well. But I do commend the PBA to you for that purpose. I found them to be extraordinarily great resource for many reasons, but they were very helpful to me when I was putting together this seminar. So the rule here is Rule 1.17. I'd like to talk, before I get into the details, about the history of this rule for a moment. Not too much, because I don't want to bore you. But when I joined PBI back in 1999, one of the first roles I took on was as the liaison to the solo and small firm section of the PBA. And I remember distinctly discussions of Rule 1.17. As a young attorney at that point, I wasn't thinking too much about retirement, but a lot of the people who were on the section then were, and they were very concerned about the ability to take money out of their firms. They had spent their whole lives building up a law practice, and really all of their effort had gone there, and that's where all their money was. And the inability to sell the firm made it very, very difficult for them to have a comfortable retirement. And I remember thinking that it really wasn't fair that someone would spend their whole lives creating something with their two hands and their minds, and in the end, not be able to take anything away with that when they were ready to stop practicing. And I remember people talking about how they were concerned about their spouses and how they would provide for them should they pass away. And all of those things came up when we were talking about Rule 1.17, and I remember that the section was very supportive of the rule, and it made sense to me too at the time, as a new and young attorney, to think that somebody should be able to sell his or her firm as long as the buyer was protected, of course. Now, there are different rules in different states about the sale of the law practice. Here in Pennsylvania, there are some things that are a little bit different, and our focus today is on sale of a practice in Pennsylvania. Now, one thing you need to understand is that if you're going to sell your firm, you must cease to engage in private practice of law in Pennsylvania. There's a difference of opinion about what that means. Now, practice of law in Pennsylvania, private practice of law, does that mean you can go into working in a corporation? Maybe. Does that mean if you're licensed in New York, you can practice in New York? Maybe. There haven't been any guidance opinions on this, so the answer is maybe at this point. But you do need to understand, if you sell your practice, you may not have another one. You can't sell your practice and open another one. That's not allowed. If you sell your practice, you may no longer engage in private practice of law in Pennsylvania. If you wish to go into in-house or something along those lines, I strongly recommend that you contact the PBA Ethics Hotline to get a guidance opinion on that particular issue, because there isn't any guidance on that yet. But crucial to understand, if you are in fact selling your firm, you're not allowed to engage in private practice in this state anymore. You have to sell the entire practice. You can't sell bits and pieces of it. So let's say you have a bankruptcy practice and a family law practice and all that sort of stuff. The whole thing, the whole kit and caboodle that's represented by this basket of eggs I've got here, must be sold. And one lawyer has to assume responsibility for all of the active files. That doesn't mean you can't sell your practice to a firm, but what it does mean is that one lawyer in that firm is going to be effectively who you're actually selling the practice to, because that lawyer is going to need to assume responsibility. Of course, the sale is not going to include any files or clients who are conflicted out, and conflicts are an issue that I'll be talking about at length as we move forward in this discussion. Now, you have to provide written notice to each of the seller's clients, and that has to be provided by the seller. And at a minimum, that written notice must include the following: notice of the transfer, the identity and address of the buyer, and that's going to be an individual, remember, that the client has the right to maintain any pre-existing fee agreements. In other words, his fees may not be raised. That the client may choose to leave, retain other counsel, that the client may take his or her file with him, and that the transfer is going to be presumed okay if there's no objection within 60 days. That way you don't have to wait forever to actually hear back from a client. You can actually go forward if you haven't heard, on that 61st day. So you want to make sure each and every one of these things are put in written notice. I suggest that you require some kind of receipt, some kind of signed receipt that the notice was delivered. Make sure you know where your clients are, or track them down so you can be sure that they are given the appropriate notice, because this is very, very important that you do this. Now, fees, which I've already mentioned just very briefly, Current agreements must be honored. So there's no raising the fees or changing the fees when a law firm is sold. The client may choose to waive this if he or she is so inclined. If you want to come up with a better scale, if the buyer wants to come up with a better scale, so be it. But otherwise, the fees must be honored, and that's the right of the client going into the sale. Why is this? Because they don't the drafters of the rule didn't want people cherry picking the best clients and leaving the clients who didn't have much to offer nowhere to go. But that also means that you have to be really careful as a buyer looking at what the fee agreements are that you might be stuck with, because if they're bad, bunch of bad fee agreements, a lot of deadbeat clients, whatever, that might not be a firm you want to buy. So you want to take a look at those fee agreements if you're the buyer. A very clear statement of responsibilities in the contract of sale, the agreement of sale, has to clearly spell out a number of things, and one thing it must spell out in relation to the clients are all the various respective responsibilities of those parties. Specifically, who is going to maintain and preserve records of the seller's practice, including those client files, because as you know, client files have to be maintained. And those files need to be maintained for 5 years. Excuse me. You may sell in case of a disability if the attorney selling is selling due to disability and a proceeding under Rule 301 has not been commenced. Then the selling lawyer is going to have to file a notice where he requests transfer to voluntary inactive status as of the date of sale. That's just something to keep in mind for those who are disabled. In case of death or disability, a third party may handle the sale. That person doesn't have to be an attorney, but that person must agree to obey all ethical rules related to sale of practice. If I may, I'd like to take a moment to address the issue of death or disability. Every attorney, but especially solos, should have a plan in case of sudden death or disability for what's going to happen to his or her firm. A firm can really go under in a very short period of time. Clients can be lost, statute of limitations can be missed. If somebody's disabled and just for a short period of time, and he or she doesn't have someone to keep the firm running, when that person is ready to come back to work, that person could be in a very bad situation. Or if the person needs to sell the firm for financial reasons and is disabled and unable to keep the firm going, there could end up being nothing to sell, and same in the case of a sudden death. So every attorney really needs to have some kind of system that makes it very clear who people should turn to. If something happens to that attorney, that information should be made available to those who maybe spouses, put a safe deposit box, put somewhere in a desk. If there's a secretary, make it clear, put a file on the computer that's called in case of death or disability, and that should include information about who the cases should be turned to. I often recommend a buddy system. You turn to another attorney that you really trust, and the two of you are there to serve as each other's partner, not in the true sense, not in the legal sense, but in case something should happen. So there's somebody there to step up and help out in case something, God forbid, should go wrong. And that's just something to keep in mind as you're going through this. Now, conflicts of interest really come up a lot when you're selling a firm, obviously. You're looking at the possibility of being conflicted out of a whole bunch of cases. If you've done a lot of insurance defense work and you're looking at buying a personal injury firm, you want to take a really good look at how many of those cases you can actually take on, or whether your clients will be willing to waive them. The sale is not effective as to any client for whom the sale would create a conflict of interest, or for any other reason that's going to be violative of the rules of professional conduct or any Supreme Court rules. Now, if the conflict is one that's in fact waivable, or the rule is waivable, that's fine, as long as the client gives, remember, informed consent. So this is one of the points at which we're returning to that concept of informed consent. So just keep in mind, as you're considering buying a firm, make sure that there aren't so many conflicts of interest that you're going to end up with no clients, and you don't want to cause yourself trouble. So keep that in mind. Now, we're going to run into an issue when we get to informed consent, which is, when do we get it? When do we tell the client about the fact that we're selling our firm? When do we have to seek permission? When can we start sharing information? And that's actually been an area of some uncertainty. And fortunately, the PBA, the Committee on Legal Ethics and Professional Responsibility, stepped into this issue back in 2010 with Formal Opinion 2010-100, in which they looked into the ethical considerations as to exchange of client information and sale of a law firm. And their opinion is very helpful, and I commend it to you to help you through this process. Before I get into the discussion of the opinion, though, I want to tell you that it's time for CLE Code number 1. Remember to write this down. Your code number is A37249. Again, your code is A37249. Write that down, please. So, back into it. We have a serious conflict here between Rule 1.6C6 and Rule 1.17 in Comment 4, both of which deal with informed consent and when you may share information to a potential buyer about clients. And we have an issue. So the PBA guidance opinion came up with this opinion, which I'm going to discuss with you. Now, Rule 1.6 deals with the confidentiality of information, and it says, and you'll pardon all this text on the screen, but it's necessary, a lawyer shall not reveal information relating to representation of a client unless the client gives informed consent, except for disclosures that impliedly authorize in order to carry out the representation and is stated in paragraphs B and C. So moving on to C, it says a lawyer may reveal such information to the extent that the lawyer reasonably believes necessary, and then we move on to 6, where it says to effectuate the sale of a law practice consistent with Rule 1.17. Okay, so what does that mean? What it means is a lawyer can share information that he needs to share to help effectuate the sale of a law practice. Great, that makes sense. But then we look at Comment 4 of 1.17, which says, and I'm not going to read the whole thing to you, but part of the text, basically, that during negotiations between a seller and a prospective buyer, that prior to disclosure of information, informed consent needs to be gotten. That's what all this text says. And focusing on the language, it says providing the purchaser access to the client-specific information relating to the representation and to the file requires client consent. So we have one thing, 1.6, saying you may share the information as is necessary for the sale. And then we have another thing, a comment, saying we have to have client consent. Wow. Fortunately, Rule 1.6C is dispositive, and let me explain why that's fortunate. Let's say you're going to sell a firm. Now, you could be going to sell a firm for any number of reasons. You could be selling the firm because you decided to retire, because you're sick, because you're just leaving the practice of law, who knows. And when you're going to sell a firm, you're in kind of a sticky position. If you tell too many people that you're selling the firm, you could end up losing your clients. You know, we're in a competitive world. People could go after the clients, especially if you have some really good cases. So there's that issue. So you want to think about how you're going to tell people you're selling a firm, broadly speaking. But also, if you tell all your clients you're selling your firm, well, what if they leave? What if they become scared? What if they think they need to find a lawyer on their own to make sure that they're properly protected? Before you know it, you don't have a firm to sell. You're out of luck. And just by the nature of the fact that you've gone forward with informed consent, you could lose your clients, you could upset your clients, you could cause them a lot of distress. You know, that's not particularly helpful to anybody. So if we're actually required to get informed consent before you can share any information with a potential buyer, and let's say you go through the process 3-4 times before you find the right buyer, and each time you have to ask the each and every client, may I share your file? Well, one is that's pretty onerous. If you've got hundreds of clients and you've actually got to get permission from each and every one of those clients, and then you've got to wait 60 days before you can get, if you don't hear from them. I mean, that's really going to make it very hard to go through the process of a sale. But also, if you're saying to the client each and every time, that client's just going to get stressed out. And it really doesn't make sense under the spirit of the rule to be upsetting your clients. That's not the goal of the rule. The goal of the rule is to create a seamless transfer from the seller to the buyer to make sure the clients are properly taken care of. So that's why Rule 1.6c is dispositive in my opinion. And if you read the guidance opinion, they really do have a very good reasoning for why they believe that the rule is dispositive. So what can you share and when? Well, I would say the when is when you're really, after you've had your preliminary discussions, it really looks like this is a potentially good buyer. And by preliminary discussions, I mean that you've really made sure that this is a person is a good fit in many, many ways. And we'll get into some of those things that make a person a good fit. So once you've reached that point, and it looks like this may really be possible, then you're going to share a lot. You're going to share the identity of the clients, the identity of any adverse parties, the matter summary, nature of the work done for each client, status of the matter, a candid description of the issues involved in the matter, any issues, positives and negatives, financial information, the billables and financial information arrangements with each client. Because remember, the buying lawyer has to follow those financial agreements. They can't change them, so they certainly have a right to know what's going on there. And a review of the complete file. So basically, everything. You really are providing everything, and that's why it's going to be very important that you really be sure that this is somebody who's a pretty good match for you before you get to this point. And again, under Rule 1.16, as long as you've reached that point, you don't have to get informed consent just yet. So let's talk about some of the related rules. Rule 1.4 deals with prompt communication, and so at what point does that begin to toll? When are you required to give informed consent? That's once the agreement is struck. That's the point at which you have to give informed consent, and I've already given you the list of things you have to provide at that point. Duties to prospective clients. Now, one of the reasons we're not so worried about informed consent is that there are already rules in place to protect these prospective clients. But in addition to those rules, you're going to want to make sure you have a really good confidentiality agreement that protects you, the seller, as well as your clients, okay? But in addition to that confidentiality agreement, there are rules that we as attorneys already have to obey. And one of them is Rule 1.18, which says even when there's no client-lawyer relationship, and even if one never happens, the lawyer who saw the information, who had discussions with the client, cannot reveal that information in a way that's harmful. And so that's going to protect any potential clients, any clients that the seller's sharing, people who would have been potential clients to the buyer. Also, Rules 1.7, the attorney who is looking at it, if he finds information that is helpful to his current clients, BGAC under Rule 1.18, he can't use that information in a way that's harmful. And actually, if he recognizes that a person who's adverse to one of the clients he's already got, and he's learning information that could be helpful to his client he's already got, he needs to stop looking at that file right away and put it aside. So we have rules relating to current clients, specific rules for current clients, as well as declining and terminating representation. These all provide protection from the seller for his clients to the buyer for the potential clients he might be taking on. We also have duties to former clients, and this is in terms of what a lawyer can communicate about clients and in terms of conflicts with clients of the seller's firm. So all of these ethical rules provide protections both to the buyer and the seller and to the clients, and they all come into play and they must be obeyed. But again, don't forget that confidentiality agreement that spells out what the attorney may and may not do. So now we get to logistics. we've got the ethical rules, we understand, we deal with the conflicts, we deal with the informed consent when we need to, we've taken a look at all of the different rules, we understand we have to stop practicing in the state of Pennsylvania. Now, that stuff's pretty complicated, but what's also really complicated is how do we get the data out to the potential buyer? How do we transfer the firm? These are all the logistics we have to deal with. Well, the first thing I recommend when you're dealing in the sharing process, when you're just at that point, is you want to make sure you put your information into an easily shareable format. To me, the best thing to do, the best way to do that is put it into some kind of electrical format for the files that you need to share. And that way, they're easily accessible by the potential buyer or buyers. Which files? Well, those are going to be any files that are from the past 5 years. And as a side note, you should be keeping a record of location and disposition of all your files. You should have a strict record retention and destruction policy with decisions made by attorneys when it comes to retention and destruction, not by staff. And clients should be informed of the policy in the initial engagement letter. And the buyer should know, the potential buyer should know what that record retention and destruction policy is, and make sure if he or she is going to alter it, that clients be informed of that as well. And everybody should know where those files are. Now, to me, files should be kept electronically, paper copies destroyed unless there's some particular reason to keep a paper copy. There's no reason to keep it. It's just a waste of space, and it costs you money to rent all that space you might be renting. So that's a side note. But keep in mind, those are the clients who we're going to be focusing on, the clients that are have been retained back those 5 years. Now, for valuation of the firm, which we'll get to in a moment, the buyer is simply going to be focusing on the files going forward. But those older files, they matter too, because you want to be keeping an eye out for any potential malpractice risks that might have occurred. But still, those files have to be maintained. Those 5 years of termination of representation, that means the buyer is going to need to keep all those files too. So anyway, I suggest you put everything into an electronic format. Utilize a scanner of some kind if they're not already in electronic format. The ScanSnap series is very popular among lawyers. As I'm sitting here recording this, I'm looking at the one I keep on my desk, which is a smaller version. The one I have a picture of here is a bit bigger. You want to scan the files you want to share, create a naming convention that makes sense, that's going to help the potential buyer easily navigate the documents, and then you put them in something that you can, share. I have SOS here. There's a lot of different ways to share data. There's Dropbox, there's SpiderOak, there's all sorts of systems. I don't recommend you put them on a hard drive and hand over the hard drive because, what if the sale doesn't go through and they've got the hard drive? No, I say you put the data online with a service such as SOS. That's got encrypted backup for only $100 a year. It can be shared on up to 5 computers. And you provide the potential buyer with a password. And then if the sale fails, you revoke the password. Problem solved. That's one way to deal with it. And of course, in your confidentiality agreement, you're going to put something about not keeping access to the data, not making copies of the data, those sorts of things. You really need to get your house in order. If you're going to sell your firm, the first thing is, just like when you sell your house, you want to make sure your house is able to put its best foot forward. You're going to stage the house, with the nice furniture and all those sorts of things. Well, you're going to do the same thing with your firm if you're selling it. If your firm is operating in the 20th century, you want to get it up to the 21st century if you can, so you can sell it. Now, there are times when you're going to be in a rush, in the case maybe of death or disability, and that's one thing. But you really want to provide yourself with enough time, if you can, to get things together. And what are those things? Well, I actually think you should have yourself a law practice management audit. Take a look and make sure everything is how it should be. Are there any HR issues that need to be resolved? Do you have an employee manual if you have employees? Are there employment policies? Are each and every job description, are they all filled out? A lot of people don't have job descriptions. Do you have any issues that need to be resolved? Do you have people who need to be fired? Get rid of them. Don't make the buyer of the firm have to deal with that. And when you're talking to the buyer of the firm, and be honest about what's going on. You don't want them to have to, you want to have to say to them, listen, I've got these lawyers, they're not very good, I think you should get rid of them. You don't want to have to deal, they don't want to have to deal with that. It's going to be a more valuable firm if you've already dealt with that issue. Make sure your law practice management's working. Make sure that you've got a good document management system. A new person's not going to be able to come in there and find documents from the way that you've been organizing them in your head. They need to be findable by this new person. He needs to be able to come in, or she needs to be able to come in and properly represent your clients. And if all you've got is some kind of system that only makes sense to you, that's not going to work out too well. You also want to pull everything together. You don't want to have to be scrambling. Before you go through the process, get all your financial forms together and make sure they're organized. Make sure there aren't any security issues. You have a security system for your firm. Are there spyware problems on your computers? Whatever. Make sure all of that stuff is resolved. Streamline your practice. Make sure that it's running as smoothly and as efficiently as possible. You know what? If you're retiring because you can't take it anymore because your practice isn't organized, you may just find out the process gets you so organized you decide you want a couple more years. You never know. So make sure your house is in order. Crucial. Now, valuation. It's hard. It's really, really hard to value a law firm. Why? Because a law firm is a business and a law firm is a practice. You have to evaluate them separately. You evaluate the business, and that's a little bit easier. And then you evaluate the practice, and that's really hard. You add the two together, you come up with the total value. I'd like to tell you it's a science, but it's not. It's an art. And there's a lot that goes into it. And there's a lot of moving pieces that are not the same when you're selling any other kind of business. Because what other kind of business can you say? What, your clients can go anywhere they want. They don't have to stay with you. You can't say, client, you have to stay with this new person, whereas you might have, there might be agreements or contracts with any other kind of business where the person has to stay with them for a certain number of years. Say you're selling a security system business where you can say, well, I've got 100 clients who have 5-year agreements with me. Well, that's pretty straightforward, yeah? But you can't do that with a law firm, so it makes it really, really hard. But we can only go on the numbers that we've got. And that's what we look at. So the business. How do we figure out the value of the business? Well, the first thing we're going to look at are the federal income tax returns for the past 3 to 5 years. Remember I said to get your documents together? This is what I'm talking about. Get your tax documents together. Pull together, you got any assets? Do you own your own building? Do you own equipment such as computers, copiers, phone systems, all that sort of stuff? Do you have vehicles that you own? Everything. Artwork. Some people have very expensive artwork. Whatever it is you might have that's owned by the firm that you plan on including in the sale. That's what we're talking about. Pull that all together and make sure you have the value such as it currently is, the depreciated value of those items. You want to deal with any debts. Make sure that you're letting the potential buyer know about any debts, leases that you might have, equipment and office leases, any maintenance contracts you might have. Do you have any subscription agreements? These days you might not have them for library services, but you might say have it for a website where you have a hosting agreement that lasts 2 years at however many dollars a month. Any kind of agreements that are a liability on the company, on the firm. You need to be able to provide that sort of information. So what do you owe? What do you own? All that sorts of data, pull it together. Big, big issue, insurance and liability. We need to know, is there a malpractice insurance policy? As you know, you're supposed to have one. If you don't have one, you have to reveal it. But you're going to have a real tough time if you've got a firm that for some reason can't be insured. Have there ever been any claims against the malpractice insurance? Or if you don't have insurance, have there ever been any claims against a particular seller? Is there availability for tail and prior acts coverage? Very, very important. Is there fire and theft insurance? Have there ever been any applications? Is there flood insurance if necessary? Is there a security system? All these sorts of things, and have there been any applications? So we're looking at anything that can raise the cost of insurance or be any risk for the future buyer. Are there any potential discrimination claims, harassment claims, workers' compensation, unemployment compensation claims? All of this stuff. Has it happened in the past 3 to 5 years? Is it possible in the future? And you want to be realistic and honest about this sort of stuff. And again, that's why you want to be sure you have a real good confidentiality agreement. The staff. A lot of law firms, a lot of businesses never evaluate their staff, which you should do. You should always be evaluating your staff. How else are they going to get better if you do have staff? I know a lot of solos don't, but if you do, make sure you evaluate them. And if you haven't done it before, evaluate them. Sit down and evaluate them. Write down, in writing. Talk with them. You don't need to tell them you're talking about selling the firm if you don't want to do that, or you can tell them if you are. That's completely up to you. Probably you don't want to tell them because you may not want to get word to go out, maybe a trusted person or two. But that's up to you. But you want evaluation so you can honestly discuss with the potential buyers what's going on in terms of the staff. Sometimes, especially if someone's been practicing for a very long time and had, a staff member for 30, 40 years, and it's not uncommon, the seller will insist that person stays with the firm. Sometimes that can be a real problem. That person could have a very high salary, a very high benefits package. Who knows? It could be an issue. That person may just be someone the buyer doesn't feel comfortable working with. And so that could really cause a problem with the sale. So if you're a seller, before you put that kind of contingency on the sale, make sure you think about it long and hard. I would say loyalty is wonderful. So is there another way to protect that person? Can we come up with some kind of buyout for that person if the buyer doesn't want to keep them on board? Is there a way to make sure that they're taken care of? So make sure you look at different alternatives. Don't be so stubborn that you can destroy the opportunity for a good sale while you're still being loyal to those employees who deserve your loyalty, because I think that's wonderful, especially in this day and age. Money to the staff. What are the salaries? Are they reasonable? Be able to say, in this part of Pennsylvania, this is what we pay. A secretary's got that much experience. Or I needed to pay this secretary this much to keep her. The economy's not so good right now. It might be cheaper for the buyer to replace people, and you want to keep that in mind. A lot of people could end up being replaced in a sale, of course. Bonuses. Do you have a tendency to pay bonuses? What do people expect? Do you have contracts with people, or are they at will? What are the benefits packages? Benefits are so expensive. What are people expecting? Or if the buyer comes in and says, what, I'm not offering this kind of type A health insurance anymore because I can't afford it. What's the deal? Have you been paying too much to your staff? Have you been underpaying your staff? Those are all things that come up, and what staff are likely to want to leave, and what staff are likely to want to stay. We'll get into why that matters too. The business itself, the buyer really should be watching for potential issues in the finances. Really go through them with a fine-tooth comb. Go through everything. Look at everything, Kick the tires and take it for a ride, right? Get a good accountant. Both parties should have a good accountant. Make sure you really understand what you're looking at before you go into purchasing a law firm. Very, very important. Before we get to the next part, I want to give you your next code, CLE Code number 2. Code number 2 is B5283. That's B as in boy, 5283. Okay, moving on. Goodwill. This is the hard part, the really hard part. And the funny thing, the rest of it hasn't been easy either, I know. But this is the hardest part. So your practice is your goodwill. A lawyer's stock and trade is his or her reputation, right? And the reputation you've built, the goodwill you've built over your however many years of practice, That's your practice. That's your goodwill. And how do we set a price for that? It's really very difficult. It's really very difficult. And the funny thing is sometimes the more goodwill, the more power that the individual had over his or her practice, the less the practice is worth. And that's the sad irony of this. So if goodwill is such a huge part, if you, the seller, are such a huge part of keeping those clients and keeping that firm running, you might want to consider staying available to the buyer in some way so you can keep that goodwill moving. I'll explain why. A lot of the considerations, one of the first considerations, the type of practice. Is it the type of practice that's completely reliant on the individual who's selling? We have different kinds of practices, and some of those practices are very, very reliant on an individual. Are you a really famous criminal law attorney? Are people calling because your name is on the letterhead and they want to hire you? Or are you in an area of law where it's more, you know what, I got in a car accident yesterday and I need a lawyer now? And not to say that there aren't PI attorneys with that same cachet, because I know there are. I'm just using it as an example. So are people calling because of you, or are people calling because of the firm? And if you walk out the door, is the business going to walk out the door with you? That's the question. And you need to put your ego aside and think about it fairly. Is the firm you, or is the firm the firm? And only you really will know that if you look at the situation fairly. If you've got other lawyers, you might want to talk to them about it. You might even want to talk to some of your clients about it. The clients you trust. Think about it. Think about it. When you leave, will the practice survive? Because if it won't, the problem is your firm's not that sellable. That's the bottom line. So you have to find a way to make it sellable. And that's why I say, well, maybe you consider staying available. Staying available not as an attorney, but, as outreach. Not the person who's giving legal advice anymore, because you can't. Unless you choose, instead of outright selling the practice, to bring the person in as a partner or an associate for a time period and to help them build up the goodwill over time. And that's a possibility too. That's a real possibility, which is why you actually want to plan to sell your firm as far ahead as you can. Because if you can do it over a year or two, that's probably going to get you a better deal when you're this kind of person, where the practice is 100% reliant on you, the person on the letterhead. So if it's not completely reliant on the seller, let's say there's a couple people in the firm, or the firm is, the type of business that can survive the main attorney leaving, well, you will then want to look at, well, how many cases did that person handle? What percentage of the income were they? How likely are those cases to remain? How much of the practice is reliant on that person? And you're going to want to look at what kind of management tasks the seller handled, and that's regardless of whether the firm is completely reliant on the seller or not. If the buyer is a person who's not so much into management, and it's a firm with a couple lawyers, then is there somebody else who can take on those management tasks? Is the buyer going to need it? Is the buyer a good manager? You don't want to have a firm, say, with 3 lawyers where the seller did all the managing work, and you bring in a buyer who's not a good manager, and now you've got a problem. So you want to think about all those issues as the buyer and as the seller. Are there other attorneys in the practice? What kind of environment is it? Is it a dressed down, casual kind of place, or are we old-fashioned white shoe lawyers? You're going to bring in a buyer who fits in. Otherwise, it's just going to cause conflict, unless you're looking for conflict. Sometimes bringing in a new young attorney who has a different approach can be a good thing. So that's really going to depend on your situation. Are the other attorneys partners or associates? Is there an associate in the firm who'd be interested in buying you out, or a partner who wants to buy you out? Are they going to be comfortable with the buyer? Are they going to be furious that you're selling? This stuff has to work. If it's not going to work, there's no point in doing it. back to the staff. Talked a little bit about the staff. How much goodwill is with that staff? Do you have an office manager that everybody knows, or a secretary who spends more time on the phone with clients than you do? You know, my secretary with PBI spent a huge amount of time on the phone with a lot of my the attorneys I worked with, and they knew her really well, and they were always thrilled to meet her. There was a lot of goodwill there. You know, so when I left, there was still some continuity between a lot of the faculty I worked with and my assistant. So that was really very helpful. Well, same situation for you. What kind of goodwill is inherent in those people? Are they going to follow you out the door, or are they going to be willing to stay on? You know, it's the other side of making sure people stay on or not, depending on their value. And what are the clients used to? What kind of lawyer are you? Are you type A personality, a type B personality, or really aggressive, or you're more laid back? You know, your clients need to be comfortable with the buyer. And if you are a type A personality and you bring in a type B or a type C personality or whatever all the different types are they going to be comfortable with that person? Or are they going to be feeling that that person's giving them the kind of representation they want? Or are they going to walk out the door? My guess would be if you're type A and the person's type B, the clients aren't going to like that. They're used to that aggressive driving nature that you've got. And they're not going to want the more laid back kind of representation, and that person's not going to fit in. It's really very important that you provide your clients with somebody with whom they're going to be comfortable, both for the sake of the buyer and for the sake of your clients and the continuity of your firm. So that's something to seriously consider. Conflicts. Again, if you're selling a personal injury firm and the person was for years in-house with a large insurance company, are they going to be conflicted out from every single case, or 50% of the cases, or a huge number of the cases? The buyer's going to have to think about that. And again, when they're looking through the conflicts, as I said earlier, if they're seeing information that could be harmful to those folks and helpful to a client they've already got, they need to stop looking at those files, first of all. Is it likely that people are going to waive those conflicts? Are they waivable? I mean, you don't want to take on a buyer who's not going to be able to handle 3/4 or half or even 25% of your clients, because those clients are not going to be serviced appropriately, and the buyer's not going to be getting a very good deal. So that's something that's really, really important. We've already talked a little bit about practice management, making sure good procedures are in place. The buyer needs to think about that. You don't want to go in and take over a firm. That's a disaster. You don't want to go in and have to have a major office management audit. You don't want to have to clean house and start firing people. You want a firm that's in the best possible condition you can have. And if it's not in the best possible condition, then you want to seriously take a look at what you're offering for it. The price should be affected by what you're going to have to do. Just like buying a house. If you're going to have to replace a roof on a house, you're going to expect the seller to give you a deal. Well, guess what? It's no different for a law firm. If you're going to have to go in and replace all the technology and train all the staff on how to use a completely new system and have that downtime, you're going to want to make sure that the firm is sold accordingly for a price that makes sense. The buyer wants to take a look at those pending open matters and make sure that he takes over the firm in a way and at a time during which he can properly make sure those clients are represented. If you've got a bunch of pending open matters and there's no way you're going to be able to take them over in time to properly represent those clients, you're going to be walking into a malpractice suit before you even started. So you want to make sure you closely look at those things. What clients are going to stay? This is what it comes down to, If all the clients are going to walk out the door, and they could, it's their right, then the buyer has lost everything, and there's no point in buying the firm. You have to follow the ethical rules in terms of communicating with your clients during the process. You have to tell them what's going on. You have to follow the ethical rules in terms of what information can be shared, which is extensive, as I've already explained. You can share a lot of information. You should only be sharing at a point at which you believe that the buyer is a good match otherwise, in terms of personality, in terms of other issues, in terms of what you know about the buyer. That's the point at which you want to start sharing information. But it's the client's choice in the end. Nobody can guarantee that even one client is going to stay with that buyer. That's the risk the buyer is assuming, and that's a very serious risk. So when the seller is thinking about what price he or she is willing to accept, understand that risk. Just because you have this amazing book of business doesn't mean the buyer is going to be able to keep it. So be fair about what that likelihood is. Paying is a big issue. Not a lot of people are going to have the kind of money necessary to buy a law firm. So how do we want to deal with it? Well, first, the buying attorney may not raise fees on existing clients to pay for the firm. I've mentioned a couple times now that the attorney can't change the existing fee agreements. Well, this is one of the reasons. They don't want the buying attorney to raise the fees on people. So you can't raise the fees to pay for the firm. Now, a lot of young lawyers these days are hanging out a shingle because they can't find jobs. There are too many lawyers and not enough jobs in this economy. Well, one thing to consider is mentoring a young attorney. Again, if you've got the time, if you've got a year or two during which you can go through that process, consider finding a good young associate whom you can train, who's interested in taking over your practice, and then train that attorney to take over. And then you can do a buyout later on once you've been ready to leave over a period of time, 6 months, a year, 10 years, whatever works for you. Hey, this can be negotiated however you want within the confines of contract law and the ethical rules and Rule 1.17. So that means you can figure out any kind of creative financing that you want to come out with, as long as it's okay under the rules and under taxes and all those sorts of things. Consider having the buyer pay each month as the money comes in. Figure out what works for both the buyer and the seller. Now, another way to consider doing this is bringing in a partner instead of actually outright selling or becoming a salaried employee yourself, taking a step back. There are a number of different ways. And in that case, you're not actually selling the firm. In that case, you're doing more of a merger situation, and then you may sell the firm later on. You have to keep in mind that difference, selling the firm versus letting someone, become a partner, or you stepping back to a salaried position, or however you want to handle it. Keep that in mind, because under, again, Rule 1.17, you can't practice. I know some attorneys who are older or who have health problems who want to be able to practice, but are also worried about the future of the firm. So they've basically created a succession plan in which they have made a situation in which they're going to do a step-down process. First, the person comes in as a partner, then the initial person who eventually is going to be the seller steps down to the stat as a paid employee, and then eventually actually sells the firm. And that's the point at which the firm is sold under Rule 1.17. So those are possibilities as well. There are all sorts of ways to do that, as long as you stay in mind of the ethical rules. I want to highlight some specific considerations. This is a matchmaking process. The buyer and the seller, the buyer and the clients, everything's got to fit. And if there are other lawyers in the firm, you've got the buyers and the other lawyers, and you've even got the buyer and the staff if there are the staff. Staff are hugely important. You've got a good secretary who's the right-hand person of the firm who's going to help that buyer, and he or she just hates the buyer. That's going to be a problem. You need to keep all these things in mind. And the buyer's got to be competent. You've got to find a good buyer who's going to provide solid legal services for your clients. Look, you've spent who knows how long creating your firm, and you want to make sure that your clients are taken care of in the future, that your clients are really handled appropriately. So you want a buyer who's competent, who's going to provide solid legal services, who's up on the law, who's up on their CLE, who's willing to stay up on the education necessary to stay up on any areas of change if you've got a rapidly changing area of the law. the buyer has the appropriate expertise and credentials, whatever those may be for your area of practice, that your buyer has a solid reputation. Look, even if you're going with a young kid right out of law school, talk to his professors, get some references, talk to, whatever internships or jobs he or she has had involving the practice of the law to make sure that that person really is a solid, a good egg, a person that is right for your clients. Make sure that philosophical approach messes with the clients. We've already talked about type A versus type B, and gosh knows there's everything else. You want to make sure that your clients, that your firm, that your partners, that your whatever is going to be comfortable with the person coming in. And as a seller, you want to make sure you can get that tail coverage. You don't want to go through the process of selling your firm and then all of a sudden the buyer's done something wrong and you don't have protection, and now you're being forced to defend yourself in a malpractice case without any insurance. That's a disaster waiting to happen. So make sure that you've got that kind of protection. So in review, Rule 1.17 on its surface is a simple rule. It lets you sell your law firm. But I think in the past hour, I probably showed you it's not quite so simple, because law firms are not simple businesses. They're very complicated. The practice of law is very complicated. And so going through the process methodically, making sure you dot all your I's, that you cross all your T's, that the appropriate buyer is found, that the appropriate seller is found if you're the buyer, that all of the financial documentation is viewed, that even before you start showing stuff to the buyer, you have a pretty good idea that he or she is a good match, so that you can say, look, I feel that this was the right time to start sharing client information, that you share the appropriate client information, that you make sure you're not looking at a buyer who's going to be conflicted out of virtually every case, and frankly probably shouldn't even be looking at your files. That's important. You want to make sure all those ethical rules are followed, and when it gets to the point where you're ready for the sale, make sure you've got good contracts of sale, good agreements of sale. Before you get to that point, make sure you've got good confidentiality agreements. Think through what you're going to tell your staff, your other lawyers, if you've got them, when you're going to tell your clients. Obviously, once you've reached that agreement of sale, now you definitely have to tell your clients. Make sure that they appreciate their rights. Make sure they know that if they don't want to stay with that lawyer, they don't have to, and that they can take their file and go elsewhere, and that's their right. Make sure that buyer is going to be a good buyer. If you're the buyer, make sure you're taking over a practice that's been ethical, that's in tip-top shape, that you're paying a fair price for that practice. If you're the seller, again, consider staying around, especially if that goodwill of yours is what's keeping that practice together. See if you can either, instead of doing an outright sale, do a step-down process and then an eventual sale, or stay on not as a lawyer, but as just, sort of a mentor who can help with the business side, not the legal side of the practice, so that if you've got a young person who needs to learn, or you've got a person who simply is going to need you to hang around, or he or she is going to lose every single client, that only behooves you, especially if you're working out some kind of sale process where you get paid over a period of time. Make sure your practice is in order if you're the seller. If you're the buyer, make sure the practice is in order, or that you can reasonably get it in order. Consider if the seller is willing to let you do an audit of some kind to make sure the practice is in order. Don't be afraid to spend a little money to make sure, just as you would do an inspection on a house, to do an inspection on the practice and make sure things are going well. Both sides should have a good accountant, and frankly, both sides may want a lawyer, especially when it comes to drawing up the agreements and making sure everything's copacetic. It's not easy. There's a lot to trip you up here, both in terms of the ethics, in terms of the business aspects, in terms of the practice aspects, in terms of the handing over and the law practice management aspects. There's so much here. And I guess that's one of the reasons why it took so long for the rule to come into Pennsylvania, because it's not easy. It's not straightforward. And we in Pennsylvania want to make sure everybody's protected appropriately. And that's why it's a complicated process. So you want to think through all of the steps I've mentioned. And you want to make sure that the buyer and the seller, or the seller's representative, if that's the case, they want a smooth transition. They want content and reassured clients, you know. They want the longevity for the future of the firm. They want to make sure that there's proper representation of all of the clients, and that there's observation of all of those ethical rules. Both sides should want that, you know. This should be a process through which the buyer and the seller work together to make sure that those clients are properly taken care of in the future. Because not only is it the reputation of the buyer, it's also the reputation of the seller as he or she leaves practice to go on with the next stage of his life. And so I wish you well. If you are considering selling a firm or buying a firm, again, don't hesitate to contact the PBA guidance opinion to get a little help with all these ethical questions. And feel free to send me an email if you have any questions. My name is Jennifer Ellis. I'm with Friedman Consulting. My email address is jennifer@friedmanlpm.com. Thank you very much. And I'd just like to remind you that you were given 2 codes. Make sure you put those on your attestation form. Submit that attestation form within 1 week of completion of the seminar, and you'll find that form in your written materials. Feel free to send me an email if you have any questions about that as well. Thank you again for attending our seminar. I hope you've enjoyed it. I wish you a great evening.